Now the question. So give me the facts of the question, please.
Hanji. Ma'am, first of all, because we are already talking about writ, so Hetal wanted to ask ki, how is a writ procedurally different from a normal suit?
Writ में आपके कोई आपका जितना एविडेंस होता है वो by when you file the writ, you file a counter affidavit. So it all goes as part of your evidence, and your pleadings are combined. Number one. Okay. आप रिट में कोई एफिडेविट बाय वे ऑफ एविडेंस नहीं डालते, ठीक है? That's number one. Number two, a writ in a suit, you have to strictly prove everything. Wherever it's your onus of proof, you have to take what the other person may have proved, or what, you know, and disprove it specifically. Okay. But in a writ, you don't have to do that. In a writ, for example, you can file all kinds of material. आप 65B लगाएं या ना लगाएं, that also can be acceptable. You understand? Downloads from the internet, whatever. The second very basic difference between a writ petition and a suit is the fact that a writ is discretionary, a suit is not. In a suit, you have to show that you fall within the four corners of a particular law which is laid down. There is a codified statute. Writ petition may, you have to show that it is an arbitrary or an excessive action or omission on the part of any government body or authority, or any body or authority which is doing the work of government. In a suit, you cannot simply go against someone on the basis that they are doing something arbitrary. So a writ petition is basically जहां पर आपके पास और कोई रास्ता नहीं होता है, there's no other option, you will go in a writ. And where you can go in a suit, you have no power to go in a writ, unless you can show to the court that you don't have an effective remedy. Okay?
Got it,
Are
ma'am.
these distinctions clear now?
Ma'am, I think they're clear, but why do we, why is there this looseness in the procedure?
Of a writ petition?
Hanji.
So because what happens is that in a writ petition, the court recognizes the fact that there may be certain situations where you may not be able to access all the material. You see, you're dealing with the government.
Okay. But then, ma'am, that is from that end.
And the writ relies more on it's a broader aspect. You're looking at arbitrary action. If you're saying something which is a falsehood, so in any case, the person whom it's adversely affecting will bring it up.
Right.
Yeah. So they don't follow the normal method of a suit. There is no examination of witnesses. There is no cross-examination. You look at the writ, the court. Normally, there are two parts to a writ. The first part of the proceedings is when they will look at the writ, they will look at a short reply or a counter affidavit to see whether or not they think it's a fit case to be admitted. And then they will go into the hearing of it. Right? Right. Some courts like Delhi High Court now have pushed it into a one-part procedure. They're not admitting writs and leaving them for subsequent determination. Usually they just deal with them and finish it off in the first instance.
Got it, ma'am. Ma'am, another question that Anandji is asking is res judicata applicable on writs?
No. No. Right. The court will bring it up that this matter has been substantially decided in some other blah, 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 blah. If the same petitioner comes up twice. But remember one thing, it can be a larger class action issue.
Right, ma'am.
So there could be individual rights which are emanating off of that class action issue. So just because a particular case has been decided in a particular way in the favor of one person is no reason why the other person won't come up. That decision would have persuasive value, but not necessarily a penalty.
Got it, ma'am. Ma'am, also just out of curiosity, जैसे in normal planes, in normal suits, we do all that. जैसे भी filing होती है, the way it is done. Is filing also different in writs?
Okay, yes. Filing is also different in writs. When you file a suit, what do? You file a plaint and you file along with it a list of documents along with documents. You in a writ, what you do is you file the writ, the petition, and in that petition itself you will annex all the annexures. The same as you do in an appeal. There's no separate list of documents along with the documents, etc.
Right, ma'am. And
Yeah.
ma'am, desk to desk procedure, I guess, would be same. जैसे छोटी
Sorry?
court, the desk to desk procedure, like we first have to.
No, that will differ from court to court, no, because आपका high court का अपना rules होंगे filing rules or whatever that you will have to apply to the high court of judicature wherever you are filing that writ.
Got it, ma'am. Hetal, any follow-up question? I've given you the access to the mic.
Hello.
Yeah, we can hear you.
Yeah. So, ma'am, my question is, if the BMC has passed some order for demolition of a particular structure, whether it will go in writ for the appeal for by the aggrieved person, whether it will go in writ or it will go in appeal.
Look, normally you should be filing it in appeal because there is a provision of appeal.
Okay.
What you can possibly do is that if the demolition is very imminent, you can file a writ petition to say that you are only asking for protection till such time as you are able to file the appeal.
So that is basically for the stay of that demolition.
Correct.
Okay.
If you feel that you will not get a quick enough response in the appeal, then you can do this.
And these all things will be filed before only High Court.
Absolutely.
It can't go with any other court in
No.
any condition.
No.
Thank you. Thank you very much.
Your appeal will go
Appeal
to the
can go,
tribunal.
Right.
So you can file an appeal. Okay. You can file a writ in 2-3 circumstances. One, if the demolition is imminent and you will not get a fast enough hearing. 2, if the tribunal refuses you the stay in the appeal. 3, if for some reason the tribunal is not functional. 4, if you file the matter, they give you a very long date and they refuse to prepone it. In all these circumstances, you can go to the court, the High Court in a writ petition.
So basically, first we have to file appeal only.
You could file a writ saying that the time is too short and the demolition will happen before you're able to get any orders. So you're just asking for stay till such time as you're able to file your appeal.
Okay. Thank you so much, ma'am. Thank you very much.
Shan Mugamdi, you are raising your hand. You have a question? I've given you the access to the mic. You have to accept the unmute request here.
Yesterday, there was a courtroom display regarding this hijab something. What madam said, actually, it was in that argument that particular writ, he has not attached any of the evidence or whatever it is. But the defense lawyer, he took 45 to 50 minutes by referring so many things to counter that thing. But that opposite lawyer was asking time, but the honorable judges, they explained to that particular lawyer what is law. So while filing itself, it clearly, madam saying it has to be filed. But particularly in that yesterday's thing, it was not filed at all.
See, when you file a writ, you must file sufficient material for the court to take cognizance. Even if
Yes,
you're
ma'am.
missing some material. You have to demonstrate to the court that there is a reason to take action because either there is a violation of some natural justice, human rights, or there is an excessive use of power, or there is an arbitrary action. Something has to be shown at the outset. If you file that, then you're good to go.
Okay, ma'am. Thank you, ma'am. Thank you.
Okay, should I move on with the next question, ma'am?
Yeah, there was somebody who was asking a question when I joined. I didn't hear the full question.
Oh yes, I think it was Mr. Raghavendra. Are you around, Mr. Gupta?
Yeah, Raghav, I'm in line.
Can you repeat your question a little
Yeah, yeah.
slowly, so everyone
Yeah,
can
sure.
understand?
Yeah, sure.
Right.
Yeah, let me start. A partition suit was filed by my father on the district judge court, Anantapur. Hello?
Yeah. Okay. Yeah.
Yeah.
Go.
Yeah, my father died during the pendency of the suit. So myself, my mother, my sisters were added as a legal heirs of my father.
Correct.
Yeah, the defendants in the suit are defendant number one. Defendant number one, preliminary decree also passed. My father's mother, the defendant number one, is also died, and her share is shared accordingly all the parties to the suit. Hello.
Yeah, I'm listening to you. Okay.
Yeah, ma'am. As per the preliminary decree, defendant number 2 got 3%, defendant number 3 got 3%, defendant number 4 got 3%, defendant number 5, who is the my junior paternal uncle, has got 30% share, and my aunt, paternal aunt, defendant number 6 got the 30% share.
Okay.
My entire family got 30% share. During the pendency of the suit, D5 sold away the 40 cents in item number 3 in suit schedule property during the pendency of the suit. Item number 3 measuring 80 cents. D5 sold away the 40 cents out of 80 cents to the third party without the knowledge of my father and other defendants.
Sorry,
As he
you
sold away
have
the
to
more.
repeat that. No, you repeat that last sentence again. What happened?
During the pendency of the suit. Hello?
Yes, I'm listening. During the
D5.
pendency of
Yeah. During the pendentility, D5, my junior paternal uncle sold away the 40 cents out of 80 cents in the cents in item number 3 to the.
Hello.
We've lost his voice, ma'am. Ma'am,
Yeah.
I know what he was saying. He had.
Just give me 1 second, please.
Schedule.
Just give me 1 second.
Hello.
Yeah, please, ma'am. Sure. Raghavendra ji, you got your audio got disconnected, so we'll
Hello.
just let ma'am come back and then we'll start answering the question.
Yeah, sure.
Sorry. Yes, you were saying that during the during the pendency of the suit, your father's younger brother.
Yeah. Sold away an accent of 40 cents, out of which 80 cents to the third party without the knowledge of my father and other dependents.
Okay.
That is what he deserved more than in the preliminary decree.
That's more than what he would have got in the final decree.
No. What would have in the preliminary decree? What he deserved, the percentage is more than the preliminary decree. What he sold away.
Okay.
He sold away. Yeah, he sold away more than the right share he's having in the preliminary decree.
Understood. Then.
All the registered same deeds were executed in the year the suit was filed in 2010. he has executed the sale deed in 2015 and 2018.
2018 and
The third-
19. Did you have a
2018
status
and
quo?
15.
Did you have an order of status quo?
No, we don't have any status quo. The
Okay.
third parties are not implemented as a defendants.
Yes.
We have filed an final decree petition. The final decree petition is pending. Yeah,
You
now
also
I
have to
want
file.
to sell.
You
Yeah.
also have to file a petition for setting aside the sale insofar as it relates to your portion.
Okay, ma'am. Actually, the problem is now I want to sell my remaining extent of 40 cents as I'm in need of money and to meet my legal family necessities to survive as there is no any source of income. The respondents 2 to 4 under the defendant except D5. My younger brother of my father are willing to say no objection to me along with my mother and sister to sell the property of 40 cents. Is there any possibility to sell the property to the third party with the permission of the court, ma'am?
Yes, there is.
Yeah, please tell to my senior counsel, ma'am. He can understand better. Please.
You
Hello,
can
good
apply
evening,
to the
madam.
court. Good evening. You can apply to the court saying that this preliminary decree has been passed and you are entitled to an X amount of share, and therefore you would like, and you are in dire need of money, and therefore you wish to be permitted to sell a particular portion which is either less than or equal to your share, which the court has already decreed in the preliminary decree, and the other defendants don't have a problem. Hello?
Raghavendra ji, follow up. I've sent you the access for mic, please.
उनको बोलो अगर
Yeah.
voice के साथ, हाँ.
Hello, ma'am. Ma'am, are you listening now?
Yes, I am.
Actually, ma'am, the problem is, except the younger brother of my father, the D5 will not cooperate with me in any manner. That is first point. Second thing, all the defendants will not come to court. They are ready to and willing to execute a general power of attorney in favor of me. Is there any possibility to get the permission from the court by taking the register sale deeds as a implied consent and general power of attorney as a express consent by all the defendants and get the permission from the court?
Look, you have one other option.
Please tell me,
Your
ma'am.
one other option is that since there is no stay, if this property is in your possession, you can actually sell it, and then you can approach the court to say that you were in dire need of money and all the defendants except this father's younger brother agreed, and you are willing for it to be adjusted against your share. कंटेम्प्ट तो बनता नहीं है बिकॉज आपका कोई ऑर्डर तो है नहीं. Hello? Hello?
Yeah, ma'am. Yeah. Ma'am, the problem is, hello?
Yes, I'm listening.
Yeah, because of the reason that it is, because of the reason that it is pending in the court, the buyers are not coming forward. So I am in opinion that I want to sell the property with the permission of the court by taking the order from the court. Is there any possibility to get the ma'am?
Yeah, you can, because you have a preliminary decree.
Yes.
If everybody except your father's younger brother agrees, he in any
Yes.
case has sold the property which is more than his share. So
Yes.
he really has no active say in the matter.
Sorry, ma'am. Can you please repeat again?
He has already sold a part of the joint family property which is equal to more than his share.
Yeah, we are ready to forgo the remaining.
No, forget about foregoing the remaining. That's the
Okay.
said mediation that you may come to and settle it
Yes.
out over there.
Okay.
But right now, what you can do is you can approach the court to say that he sold this property. It's
Okay.
more than his share. Therefore,
Okay.
in the present corpus, he has no share.
Okay.
All the other people are agreeable that you should sell it and that it will be adjusted against your share of the eventual share of the total joint family property.
Yeah. The
You're in
problem is
dire need
here,
of
yeah. The problem is
You're
here
in
all
dire-
the remaining shareholder, all the remaining defendants will not come to court, but they are telling that we will execute a general power of attorney in favor of you. You can sell the property with the permission of court. Is there any possibility that by producing the general power of attorney is an acceptance by all the remaining defendants and get the permission from the court?
Yeah, you can say that. You can say they're willing.
Okay.
They have executed. Please take the executed general power of attorney and place it as a document with the court
Okay.
and say that they've executed general power of attorney. They have no
Okay.
problem.
Yeah,
And
the
they are willing for you to sell.
okay, ma'am. The remaining defendants need not to come to court, right?
Look, if the court insists that they come to court, then the court will insist, right? But now nobody can do anything.
Okay, okay.
The other thing you
Okay.
can do is, it will be a little expensive proposition.
Yeah, ma'am.
You can take their affidavits, put them into the court, and in case the court want that they have no problem to your selling the property and your father's younger brother has nothing to do with the property anyway.
Okay.
And then if the court wants them to come, you can request the court that since they are unwilling to come to the court,
Okay.
can you appoint a local commissioner at my expense to go and take their statements?
Okay, ma'am. Only to the extent of this item, right?
Yes, of course.
Okay. Okay.
And you will only adjust it against whatever is owed to you.
Yeah. The remaining share should be proportionately adjusted.
Correct.
Okay, ma'am. Thank you, ma'am.
Right, ma'am. I wanted to know if.
Madam.
Oh, sorry. Yeah, please.
Hello.
Yes, please.
Madam,
Yeah.
I got another question.
Yes.
Section 73 CPC, rateable distribution.
Sorry?
Section 73 CPC, Civil Procedure Code,
Yes.
that is in respect of rateable distribution between several decree holders.
Correct.
So in that, I want to know which court will have jurisdiction. Suppose there is a senior civil judges court is there, and then principal junior civil judges court is there, and property was attached in both the courts by several creditors. So one of the creditors on the file of principal junior civil judges court has brought the property for sale, and sale was also confirmed. So as far as the EPs pending on the file of senior civil judges court are pending, and in the meanwhile, I have filed an application before principal senior civil judge saying that the property has been already sold by this honorable court. So rateable distribution is to be done by this court alone. So I have filed the certified copies of EPs before the principal junior civil judges court. Is it correct procedure, or I have to take action in the subcourt, the senior civil judges court? Because the funds are already vested with the principal junior civil judge court after actioning the property.
No, you have to file. You have to file in that court to stay the funds so that they are not released to anybody except.
Hello, madam. Please repeat. I have to file an application.
Who will be liable to receive those funds if the no, I'm a little confused. Okay, So first of all, who are you representing?
I am representing the decree holder who has filed the EP on the file of Senior Civil Judges Court. So like that, there are 4 to 5 decree holders on the file of Principal Junior Civil Judges Court. And
Now, as
what
far
I
as you are concerned, no, one moment. Why would you want to go and put your head in the hornet's nest? You have got a decree. You have executed that decree.
Yes.
The property has been sold. The funds
Yes.
are lying with the Senior Citizens Tribunal.
Not Senior Civil Judges Court, the other court, the Junior Civil Judges Court, where
Okay.
some other decree holder has brought the property and that property was actioned in a sale, public sale.
I see. No, then you will go to the senior judge. You will ask for the matter to be transferred along with this decretal amount, and because there has to be a proportionate sharing.
Oh.
Yeah, you go to the senior judge.
But the thing is, because already the properties are sold out by Principal Junior Civil Judges Court.
But the funds are still there.
So can I file an application before that particular court and say this is the EP amount that has been pending in respect of the decree, and so I have to be distributed ratably, including the other creditors, including the
That
other
is only a
DHs.
holding application. Take it to the senior judge and ask him to transfer the execution and deal with it in a combined fashion according to section 73.
So what I know is section 73, the court which is having the assets has to distribute the funds. And then
Yes, that
I
is
have to-
correct. But right now, what the problem is that you have a difficulty because the assets are lying with one court, but your decree is emanating from another court.
Yes.
Therefore,
All
you
of them
need
have
to-
moved the applications, madam. The decree holders who have filed their EPs on the file of Senior Civil Judges Court, they have filed applications on the file of Principal Junior Civil Judges Court.
No, you
stating
have
that-
to file an application to say that they have to hold the funds. They cannot disburse them because you also have an equitable interest in in those funds, right?
Oh, yes, madam.
Because there was already a previous attachment. So that holding application you will file with the senior civil judge. When you file that application, you can say that you can transfer this matter because the senior is entitled to deal with the junior's matters, but the junior is not entitled to deal with the senior's matters.
Yes.
So transfer
So
it
where
so
I have
that
to file the application?
no. Now my question is that where is your case pending? Your case is pending
My
with the
case is
district
pending on the file of Senior Civil Judges Court,
and the
which is a higher court, appellate
Okay.
court.
right. So therefore, appellate court, the execution will always go with the court of original jurisdiction. So if you started from the lower court and then moved to the senior civil sub-judge, then in that case you have to still file the execution with the junior civil sub-judge because he's the one who passed the original decree. Did you file in the senior civil sub-judge because of pecuniary jurisdiction, or did you file in the junior? Is your current pendency an appeal, or
Please
is
let
it
me clarify, madam. So my case is that I have filed 3 execution petitions for different decree holders on the file of Senior Civil Judges Court, and the same property was ordered to be attached, and the property was also attached. But in the meanwhile, some other decree holder, not relating to me, some other decree holder,
No,
through
sir,
some other
I want to
advocate,
ask you. So if you have filed the executions in the senior civil sub-judges court, it means that
Yes,
your
yes.
original action emanated from there, right?
Yes.
Therefore, what you need to do is you need to file 2 simultaneous applications, one to the senior civil sub-judge, one to the junior civil sub-judge. In the senior civil sub-judge's application, you will write that this property which we have asked for attachment for already stands attached, but the funds have not been disbursed, and if the funds are currently lying within this court in the jurisdiction of the junior civil sub-judge. Okay, now in view of section 73, I'm entitled to a proportionate share. Even if I can't get my entire money, I'm entitled to a proportionate share. Everybody has to be given according to what they're owed proportionately. Correct? Therefore, since this matter is pending with you, you're requested to ask for the transfer of the execution petition to yourself and therefore and deal with the matter.
Okay.
Okay. You
So I
want
have
to
to move
shorten
two
this
applications.
process? You want to shorten this process? File an application with the district judge,
Okay, ma'am.
right? You can say that
Okay.
these matters are pending, one with the senior civil sub-judge, one with the junior civil sub-judge. In terms of section 73, you have a pro rata interest in the property which has been attached. The funds are still lying in the court. Therefore, this matter should be transferred to the senior civil sub-judge and dealt with holistically for all the decree holders.
Mhm. So then I have to include all the decree holders also when I file an application before.
Correct.
Because they are also the decree holders, so they
Hmm.
have to be brought on record.
Yes, of course you will have to. But once the execution file comes from the lower court, automatically those decree holders will be there.
Okay, ma'am.
Yeah,
Okay.
Yeah.
So may I ask another question, madam?
please.
So in a suit for partition filed by sister against her brothers and the purchase third party, they have purchased some property from the brothers, excluding the sister. Sister has not joined the execution of the partition deed entered between her brothers. So
When was the
subsequently,
partition deed? No, stop. When was the partition deed executed?
it was executed in the year 2010 and immediately a suit was filed in 2011 itself after giving notice to her brothers.
I see. And is this ancestral property or is this self-acquired?
The brothers have executed a sale deed in favor of third party and I have filed a suit for partition through her. The sister is the only plaintiff against her brothers and the purchasers. The brothers have remained ex parte and only the contesting party is third party.
Yes.
Is it necessary for me to seek cancellation of document also, which is in favor of third party? Is it necessary for me? Because
No. How can you seek cancellation? Because what the brothers have sold, that can't be cancelled. You can only ask for it not to apply to you as far as your portion of the property is concerned, and your partition suit should be decreed and the decretal amount should be handed over to you, whether in terms of actual physical possession or in terms of money.
madam, unable to follow, madam.
Okay.
No, you said that
You cannot ask for setting aside of the decree.
no, not setting aside of the decree.
No, sorry, you cannot ask for setting aside of the sale deed.
Sale deed. So simply I can ask for partition, ignoring the sale deed executed by my client.
No, not ignoring the sale deed. What you can say is that the sale deed should only be applicable to the extent that the brother's share is there. Yes, not my share, because I have never sold. So that share should be handed over to me.
Yes, madam. But but my submission is, I have filed the suit only for partition, even though I have mentioned that so and so parties, that is dependent 7 and 8 have purchased
because the difficulty is that you cannot set aside an entire sale deed when you do not possess the entire property. You only possess, let's say, 1/4 of it. For if there are 3 brothers and 1 sister, you possess only 1/4 of it.
Now, what I mean is seeking cancellation of those documents in favor of third parties to the extent of my share. To the extent of my share, the document is to be
a document is either cancelled or not cancelled. When you sue for partition, what are you saying? You are saying that your share should be handed over to you, and your decree becomes your title.
Yes. So that relief itself is sufficient, madam. Any other relief is to be added.
Yes. Yes.
So I have clearly mentioned in the prayer, seeking for partition and separate possession of my 1/5 share and allot
Yes.
the same to my share with reference to good and bad soil.
That's right. That's an absolutely correct prayer.
So no need to seek cancellation of the document.
No, what you can do is in prayer number 2, you can say in a specific direction to the effect that to the extent of 1/5, the sale deed will not apply.
Yes, yes.
Yeah.
So that it says because the third party has already purchased the property. So
Correct.
I thought that is also a necessary party because if the partition suit is decreed, then my share will be described or my share will be measured by the commissioner, advocate commissioner, divide it into 5 parts and allot me 1 plot through the court.
Absolutely correct.
Right. Okay, madam.
If the property is capable of being
Because
divided by means and bounds.
Because recently I had gone through one decision of
Huh.
Andhra Pradesh High Court, wherein the court said that, of course, there was a long delay in filing the suit for partition by one of the co-owners. So there, the lordships held that without seeking cancellation of the registered sale deed, you have no voice unless and until you have taken such a plea or unless you have paid the court fee for cancellation of the document. Maybe because of the long duration between the parties, court might have come to the decision what I thought.
Number 1, where are you filing this suit?
Madam,
Where have you filed this suit?
this decision, madam.
No. Where is the property situated? Your property.
Raghavendra ji, you muted yourself. Please unmute yourself.
Hello, madam. Sorry for the interruption.
Yeah. I am saying to you, where is your property situated?
My property is situated in Anantapur district, Andhra Pradesh.
Okay. In that case, please add a prayer for setting aside, because this is a decision which may be right or wrong, but it's a decision of the High Court, and therefore, as far as the district court is concerned, will be binding.
But the thing is, already I have filed the suit in somewhere in 2010 or 11. So already by this time, even seeking cancellation of the document is barred by limitation.
Yes. So then you just progress as you are. You don't have an option.
Okay.
Because this decision has a binding ruling. According to me, this is not a correct decision, because the sale deed cannot be cancelled. No, because the sale deed cannot be cancelled for all the parties. It can only be cancelled for one party, right?
Yes.
Who has not signed it, or the parties who have not signed it. Okay. And it has to be effective for the balance of the parties. But having said that, please understand that a decision, even if it's wrongly given, if it's of a higher court, has a binding value on the lower court.
Yes, ma'am. Yes, ma'am.
So that way,
because almost all the decisions I have gone through prior to that, they say that super partition itself is sufficient. I need not go or seek for cancellation of the document.
Correct.
Okay, madam.
Yeah. Okay.
Okay, madam. Thank you very much, madam.
You're welcome.
Thank you so much, ma'am. Ma'am, isme I wanted to ask, when there are such cases, after that, we have to file an application for status quo. So isn't the the res sub judice already applied on it? Lis pendens?
No. Remember, res sub judice is when two cases are filed.
Okay.
So res sub judice happens when two different people, so maybe the plaintiff in one and the becomes the defendant in the other case.
Ma'am, not res sub judice, lis pendens. My bad.
Huh?
So lis pendens doctrine, if it applies, it should apply impliedly. Na? When there's a case going on, you cannot sell a property off.
No, you have to ask for status quo, because if you have a specific order of status quo, then you are entitled to file contempt of court.
Okay.
But if you don't have a specific order, then there is no contempt of court.
All right. Okay,
Yeah.
ma'am. That's important. Okay. Mr. Sumit Kalra, you had raised your hand. If you would want to ask your question, although you've not connected to your mic as of now, so you might not be audible to us. Anyway, I'll just move on to the next question. Ma'am, whenever a suit is filed, is it open for the respondent to file an interim application? Is it like is it a general rule?
Yeah, it's open for you to file an interim application, but please remember that as a defendant, you cannot get some benefit in a suit filed by another.
For example?
So, for example, if somebody else has filed a suit and you say, oh, actually, this is not the position, so declare this to be the position. And you are seeking to get advantage out of that. Supposing, for example, you are wanting to confirm your own title, it can't happen.
Okay, right, ma'am. And ma'am, also, there's another question by Hetal. She wants to ask how to file a suit under Order 38, as in my knowledge, it is in conjunction to Order 37.
How to? I don't understand. What do you mean, how to file a suit under Order 38?
Hetal, please clarify. You've not unmuted yourself.
Hello.
Yeah, Hetal.
Yeah, ma'am. So my question is, this order 38, which is judgment attachment before judgment. So can it be filed in any kind of suit, or it is only in conjunction with summary suit, that is for the recovery of money or something like that?
No, in fact, in a summary suit, when will you file it for
No.
attachment before judgment? Order 38 is something you can use anywhere. For example, if the defendant doesn't show up, and you are afraid he's going to run away from the jurisdiction of the court, or he's going to get rid of all the properties, or you have knowledge that he's trying to sell the properties that he has, or remove his assets from the jurisdiction, you can file an Order 38.
Okay, ma'am.
Yeah.
Okay. Yeah. Thank you so much.
You're welcome.
Moving on to the next question, ma'am. Give me 1 second.
Okay, guys, this is the last question. I'm going to make this the last question.
Can we make it the second last one, ma'am?
All right.
It actually is the second last.
Okay.
Okay. This is from Mr. Ravi Ahuja. He wants to ask, does a defendant have the right to implead a third party as proper party under Order 1, Rule 10, Sub-Rule 2, and Dominus Litis? Does Dominus Litis doctrine have any effect on it, barring it?
It depends. No, why would you want to implead someone as a third party? Explain, please.
Ma'am, as far as I can think, would be something like if I'm asking for money from my employer and he says, employer or anyone else, he says that this is my partner, and he's also liable to pay, or something like that. He also impledes the defendant in that, impledes another party.
No, why would you do that? Why would you do that? Explain this to me. I'm only liable to pay my share of it, right?
Right.
I can jolly well say that I'm supposed to pay for 50% of it, not the whole. Let's say, for example, what is the circumstance in which you would want to implead another defendant? It's for the plaintiff, no? Supposing you have passed on your interest to a third party, supposing you are not taking on the onus of responsibility of the entire litigation, then it's for the plaintiff. Why? I don't understand why a defendant would even want to push in a third party. All you will do is say that whatever is on the third party is not my onus. Why will I discharge it? I'll only discharge whatever is relevant to me, no?
Right, ma'am.
So let's say if a plaintiff is an idiot and he decides that he's going to sue one partner by name and a partnership firm of two partners, then it's his loss.
Right, ma'am. Ma'am, there's another question extending on to this question itself, which says, what is the jurisprudential intent of the provisions of examining parties? Okay, this is from Order 10. What is the jurisprudential intent of provisions of examining parties under Order 10 Rule 1 in context of ascertaining the admission or denial of allegations by the parties, when in fact the issues are still to be framed to decide the dispute?
Look, there are certain things. What happens is, for example, there are certain letter. Now, I say this letter generated from the defendant. And I'm putting him to strict proof to say, you accept or reject this letter, then I'll take my own steps whether or not to prove it and how to prove it. And the rules that follow then are very clear, because if you are taking on the burden of extending a litigation, you're also responsible for it. I'll give you an example. Let us say that you have sued in relation to two properties which you are claiming ownership of. One property is in the jurisdiction of Chennai and one property unfortunately happens to be in Himachal Pradesh, right? Now, in order to prove the Himachal Pradesh property, you would have to get the registrar of sub assurances, somebody from his office, to come all the way from Himachal Pradesh to Chennai to the court to depose along with the register, etc., etc. You have to pay a huge amount of money. His airfare, his staying, his diet money will, take all that. Why should you pay for it? If he denies that registry, then at least the defendant will be responsible for all those expenses.
Got it, ma'am.
Okay.
Right. And ma'am, the very ultimate last question, someone wants to ask, if you are taking domestic violence, why don't you take the complete family laws?
Let's start with domestic violence. Let's not jumble up everything together, because then it becomes too much of a khichdi and a mess.
Right. Although
Yeah?
the way that we have learned CPC, domestic violence karte we are going to dive into a lot many subjects and learn about them.
I'm going to be very strict and say, this is outside the purview. I'm not going to do it.
All right, ma'am. We'll try to compel you to permit us.
Take care. All right.
Right.
Bye,
Thank you so much,
everybody.
ma'am. Thank
You're
you so
very
much for
welcome.
writing W38
Good
times.
night. Ajay, Raghav, now make me leave. Otherwise, half an hour I'll be just fighting with this thing to leave.
Yeah, I'll do that in just 1 minute, ma'am. Everyone, the old ones in the meeting, you already know about ma'am's course on CPC, and you now know about DV course. DV course will come in March, so I'll share the link with you again in the channels. All those who are new, I've already shared many times in the chat. So you can check out the CPC and CrPC course and enroll in them, and they're super duper cool courses by super duper cool faculty members. And you can get reviews from your co-participants as well. Thank you so much. Have a very good evening, and we'll meet you in the next session, whenever it is.